5 seconds to go. Start. One of the contentions raised by the petitioners is that the Delimitation Act 2002 contemplates the constitution of only one delimitation commission and not more than one. As noted earlier, the Delimitation Act 2002 was made applicable for the first time to the state of Jammu and Kashmir with effect from 31st October 2019. Even the Delimitation Acts of 1962 and 1972 were not applicable to the state of Jammu and Kashmir. By virtue of the J&K Reorganization Act, not only provisions of the Delimitation Act 2002 were made applicable to the Union Territory of J&K, but a mandatory duty of readjustment of the constituencies in the Union Territory, both of the Legislative Assembly and Parliament, was entrusted to the Delimitation Commission by subsections 2 and 3 of section 62. Till 31st October 2019, the Delimitation Commission for the State Union Territory of J&K under the Delimitation Act 2002 could not have been established as the said enactment was not made applicable to the state of Jammu and Kashmir till then. Subsection 6 of Section 10 of the Delimitation Act 2002 reads thus: The Commission shall endeavour to complete and publish each of its orders referred to in subsection 1 in the manner provided in that subsection 2 within a period not later than 31st day of July 2008 under section 3. Subsection 6 uses the word endeavour. Section 10A of the Delimitation Act 2002 itself indicates that the time limit of 31st July 2008 fixed under subsection 6 of section 10 is not sacrosanct, as it confers a power on the Honorable President to defer the delimitation exercise in a state under certain circumstances. Thus, the time limit provided in subsection 6 of section 10 was never intended to be mandatory. While amending section 2F of the Delimitation Act by the J&K Reorganization Act, subsection 6 of section 10 has not been amended for enlarging the period provided thereunder. However, the intention of the legislature as reflected in subsections 2 and 3 of section 62 of the J&K Reorganization Act is crystal clear. The very fact that the duty of making the readjustment as per subsections 2 and 3 of section 62 on the basis of the 2011 census figures has been entrusted to the Delimitation Commission suggests that the legislature intended that the Delimitation Commission for the Union Territory of Jammu and Kashmir will remain unaffected by the requirement of completing the exercise by the end of July 2008. The provisions of subsections 2 and 3 of section 62 will have to be interpreted in a manner that gives effect to the intention of the legislature. If it is held that due to the failure of the legislature to modify the time limit provided in subsection 6 of section 10 of the Delimitation Act 2002, the central government is powerless to appoint a delimitation commission for the newly created union territory. The provisions of section 62 of the J&K Reorganization Act will be rendered nugatory. A statute cannot be interpreted in a manner that will render some of its provisions OTOs. A statute must be constructed and interpreted in such a manner as to make it workable. Therefore, the argument based on subsection 6 of section 10 of the Delimitation Act 2002 will have to be rejected. Articles 2 and 3 of the Constitution enable the Parliament to create new states and union territories. Accordingly, the two new union territories have been created. The J&K Reorganization Act, which created the two new union territories, assigns the role of readjustment of constituencies to the Delimitation Commission under the Delimitation Act 2002. Stop.